Thank you, Councillor. Welcome, delegates. My name is Paul Railton-Smith. I speak from a company called True Bearing Chartered Financial Planners, and we are retirement planners, not salespeople. We're complemented at True Bearing Chartered by having our own legal services. Now, on the legal services side, we look at legacy planning in great detail. We have to pass our wealth on at some point in our lives, as I'm being constantly reminded we don't have pockets in shrouds. So we need to be able to pass it on in the correct way. Now, most people will say that's a will. I absolutely agree, but there is so much more that goes beyond that. I'm hoping today that you might see and hear something with the presentation that Mark Peary will give in a minute, and you want to find out more about it. Stuart Duncan will be issuing a feedback survey after today's webinar, and there will be a link on there that will allow you to come directly to True Bearing Chartered Financial Planners, and we'll be able to arrange a meeting with you and with Mark privately at no cost. So if you wanted to discover more, hear more, and be more part of what you need to do with your planning, then we'll be able to do that for you. I'm going to introduce to you now a gentleman by the name of Mark Peary. Mark is a legal intermediary and has been with True Bearing for quite a number of years. And he will walk you through this presentation on what more you can do with regard to legacy planning and how to take that forward. Mark, are you ready to share slides?
Thank you, Paul. Thank you for the introduction. Good afternoon, ladies and gentlemen. You'll be pleased to know that I'm going to be talking to you today about death, doom, disaster and everything else that can go wrong in life. You can tell from my expression that I tend to do that with a slightly lighter touch to the subject. It's quite an intense subject, but I hope it's quite interesting for you, and please don't be offended at my slightly macabre sense of humour on occasions. But let's get cracking with the presentation because we're a little bit short on time. So, as Paul says, my name is Mark Peary. I'm going to talk to you today about wills, trusts, lasting powers of attorney and all that sort of palaver, so to speak. Now, if I were to ask the question, how many of you currently have a will, I would hazard a guess to say that 70% of you probably don't have wills. It might be higher, but generally, statistically, 70% of people don't have wills. That means that if you die, the government will decide where your assets are going and who's going to get those assets. That might not be in line with what you want to happen or think might happen. Now, a will is a good thing, but I would put to you that if you went to buy a new car, if everybody in the audience today decided to go and buy a new car, some of you might go and buy a Ford Fiesta, which is a perfectly good car and it's perfectly adequate and good, fit for purpose. It does what it says on the tin. Good looking, economical, fit for people. But some of you might need a Harley Davidson motorcycle. Some of you might need a big estate car or an SUV to carry the dogs in and family in and all that stuff. So the Ford Fiesta, whilst good and necessary, isn't exactly the right thing for everybody. And the same is said with a will. Now, 98% of people that go to a solicitor come out of the solicitor's office having gone in to get their affairs in order with a simple will, and that's okay. But it doesn't cater for all the things you can see on the screen at the moment, and those are different wishes, different needs, different families, different circumstances, different assets, and different risks. They all lead to different risks within your family. And a will, whilst ordering your estate and telling who's going to get it, doesn't guarantee, because of those things, what will actually happen when the time comes. As you can see, legacy planning is not a one-size-fits-all issue. That's why we've all got different families, entirely different. And what we're going to look at today is legacy planning in more detail. Now, the strapline is making a plan in advance to pass on our family wealth. Please don't get caught up on that word wealth. Wealth is relative to you and your family and your circumstances. If you're a multimillionaire, fantastic and good luck to you. If you're not, then you still need your affairs in order. And we all need to make sure that when you put your head on your pillow at night, that everything that you want to go to your nearest and dearest is going to go to them and not to anybody else. And that's what's really important. A good legacy plan also deals with your wealth, but in the event of death, we know about that, or incapacity. A will won't cater for incapacity and losing the ability to make your own decisions. So the legacy plan needs to do that. And it's also about protecting our wealth from a whole host of threats by having the certainty that your wishes are carried out. Now, again, a will, for many reasons, won't give you the certainty that your wishes will be carried out, and I'll show you those reasons shortly. We're going to whiz through a few what-if scenarios, and to do that, I'm just going to introduce you to our cast of people. If you imagine it's the worst case of Emmerdale or Coronation Street you can ever imagine, it's not a happy episode by any stretch of the imagination, and you can see the smiling face cast members all smile all the way through this, but trust me, this shouldn't be smiling at the end of it, but unfortunately we've not got the good enough graphics to make them frown. So I'm going to introduce you to Harry and Janet. If you imagine Harry and Janet are sat where you are now, listening to me into the afternoon talk about this macabre subject, and at the end of it, they decide, yeah, okay, well, we need to know a bit more. So we'll have a meeting with Mark, and they go through the process, and they end up face to face with me, or via Teams or something like that, where we can meet and discuss their needs. And that's what we're going to do with Harry and Janet. We picked Harry and Janet just because their needs are really, really simple. And when your needs are simple, I want you to show you really what can go wrong with even the simplest plans. So shall we crack on with a little bit about Harry and Janet? So when we sit across the kitchen table with Harry and Janet, with maybe a cup of coffee or whatever, I find out that they're married, they've got their own home worth approximately £300,000, so they're doing okay, got a nice house. There's no mortgage on that. They've got savings of about £50,000. Hopefully they'll spend some of that having a nice, happy, healthy retirement. They've got a son, Bob. He's married to the lovely Jenny, and they've got one grandchild, James. Keep an eye on James, because he's a victim of all this quite a lot. Now then, as we chat on, I discover that they want to leave everything to each other in the first instance. Those of you with wills might know that as a mirror will, so that when Harry dies, everything goes to Janet and vice versa. No inheritance tax payable on first death with a married couple. So her inheritance tax limit at that point, when Harry dies, could be up to 650,000. It could be a little bit more as well, depending on what we're doing. Then, after they've both passed on, they want £20,000 to go to their grandson, young James, when he turns 18. Those of you in the audience with children or grandchildren might know that an 18-year-old boy is unlikely to invest that £20,000 in a sensible manner to build it to a deposit on his first home. He's likely to invest it in a John Cooper Works Mini with a big fat exhaust and big tyres on it, and that's likely to end up, and I know this from personal experience, in a scrapyard about 4 months down the line. So think about the age of your beneficiaries when you're thinking about wills and leaving things to children and grandchildren. £20,000 is okay, that's a nice amount, but the other thing you've got to think about is if you live for another 20, 30 years, that £20,000 in spending terms will be about half what it is when you intended it. So maybe percentages might be better. The remainder of the estate is to go to Bob. That's the son. So dead simple wishes, really, albeit a little misguided with the grandson. So what they want is to protect their assets for their own use during their lifetime. So they don't want to shove everything under the bed in shoeboxes and watch it depreciate, and then everybody gets it when they're gone. They want to have some involvement and some influence over that, and they want Bob's inheritance to put him in a better financial position, and ultimately, excuse me, I'm nearly choking, to give James a better start in life, so he's got the most out of everybody at the end of the day. And that graphic just shows the progression of the estate from Harry and Janet down to Bob and Jenny, and ultimately across to the lovely smiling grandchild James. So no issue there. Again, very, very simple. This is what they wanted, what's important. They want to protect their assets and their loved ones' inheritance during their lifetime. We know that already. They want to ensure that Bob and James don't lose their inheritance, or that their inheritance doesn't shrink. So if you're named in a will, how can you not receive your inheritance or your inheritance shrink? We'll look at all these scenarios shortly. They want to eliminate delay, so they don't want it to go through probate, or they want probate to be really simple. And they want to be sure that bloodline inheritance is maintained, so it's not going to other people's children who've come into your life and other people's ex-partners of your children, all these sort of things. They want it to stay in the family bloodline. Don't want to be a burden if they lose mental capacity, and they want to keep costs down as well. Who wouldn't? So this is the thing they need to consider. Sideways disinheritance. I'm a legacy planner, and sideways disinheritance is my enemy. That's what I want to defeat at every turn if we can, to prevent it happening to you. So these are the areas that we're going to be covering off. What if one of them was to remarry after first death? This is a real bugbear. Something drastic happens if you get married or remarried, and I'll touch on that shortly. What if Bob were to die young? What if Bob were to get divorced? Or what if Bob were to suffer financial hardship? All these three things are totally out of the control of Harry and Janet. They're the things that Bob did or choices that Bob made. So again, how can that impact on what you want to leave to your children? What if they were to lose the ability to look after their own affairs, i.e. lose their mental capacity? And what needs to be done so they can keep the costs of probate and things like that down? So we'll have a look. Let's start on the scenarios now. Now, for the more sensitive of you in the audience, Harry's going to disappear shortly, so I'll prepare you for his demise. I do have a background with Crew's bereavement care and counselling the bereaved a little bit, so I'm used to this, but most of you won't be. So we're going to say goodbye to Harry shortly. Gentlemen in the audience, we tend to predecease our female counterparts by a couple of years. I don't know why that is. I think it's to do with big motorbikes and falling off ladders and things like that. So take care. Harry's not done, and Harry's going to depart before Janet. We know they've got a mirror will in place. That's all they've got in place. So say bye-bye to Harry. He disappears into the ether. Janet now sits on her own. She's inherited the whole estate, because she had a mirror will. No inheritance tax payable if there was at that stage. And if everything stays even and equal, when she passes, that'll pass to Bob and to James, and the whole estate moves to them. So that simple will on that occasion worked because there was no intervention. Nothing else happened in their lives. So everything was dead simple. The problem comes when Janet decides to get remarried. Now she discusses this with Bob, and he's quite happy now that Janet, his mum, is getting remarried because the onus isn't on him now to look after her quite as much. So she decides to get remarried. Who's she going to marry? Well, compared to Harry was a bit of a wildcat. She marries the steady Clive. He's a bit of a bowls club member, enjoying himself. He plays a little bit of golf, very steady in influence, and he's a good influence for Janet. They start to go on cruises and do all the things that married couples do. They've got fantastic companionship. Bob's really happy at the moment because, again, he's getting on. His mum's happy. She's come through the grief a little bit. Crucial thing happened though. As soon as Clive and Janet got married, and it happens to both of them, I'm only going to concentrate on Janet. When Janet got married, this moment she signed that marriage certificate in the registry office or church, her will is now void. So she has no will. She's gone into the marriage with Clive, and because she's no will, and she's a married lady now, Clive, her husband, is entitled to half of what she has. Bob's getting a little bit twitchy now, and particularly he's getting a little bit twitchy because Clive is a gentleman of a certain age, and he brings his son to the party as well. So that's his family. So we're getting another family involved. Wayne's done nothing wrong, neither has Clive. But Bob's getting a bit twitchy because Wayne's just turned up with a nice new sports car, and Bob's thinking, has that come, they didn't seem to have any sort of spare money really, so has that come out of my mum's bank account, also known as my inheritance? So he's getting a little bit twitchy and a little bit wondering, and with good reason really, because don't forget, Janet's no will. If Janet now predeceases her new husband Clive, i.e. dies before him, that's where she goes. I should have prepared him more for her demise. But you can see the result. The links to Bob and James completely disappear. Clive sits on the whole estate, and Wayne and Clive are the ultimate beneficiaries. Now, Janet knew Clive and Wayne. Harry didn't know any of these people, but they're the ones that have walked off with the loot at the end of the day. Bob and James done nothing wrong. They've just been completely disinherited by the act of remarriage. Now, I was speaking to a client just two weeks ago, and she said, that's exactly why we're having this discussion, Mark, because my dad got married after Mum had died. We had a great relationship until we got a text off the family saying, oh, by the way, your dad's died. There's no funeral, so don't bother coming. He'd passed all the family wealth on to the new family instantly, just like this scenario. Another instance very similar, Linda Bellingham, the Oxo lady, if you remember Linda, just before she died, she was remarried. Just before she died, she was poorly, made a new will. at the insistence of a husband, leave everything to me, my darling, and I'll look after your sons. He didn't look after his sons at all. Linda died, he kept the £5.2 million estate, didn't give the lads anything, and they had to challenge the will. They came out with a small proportion of it, nothing like the 5.2 million. And again, legally, nobody did anything wrong. Morally, maybe it's a different question. And this happens an awful lot. Money goes sideways out of the family very, very quickly by remarriage or marriage. So be really careful about that. So, moving on. Another scenario, what if Bob died prematurely, really, or before he should? So Bob was married to Jenny. Harry and Janet have passed away. So now Bob sits on, he's inherited from his mum and dad, so all's well. But what if he died young? He goes very quickly. The estate passes to Jenny. Jenny's got James, so James, ultimately, ultimate beneficiary, is still going to get the money. He's still smiling, God bless him. So what if Jenny decides to get remarried? Now, who do you think, just for dramatic circumstances, who do you think she's going to remarry? I'll give you 1 second. It's not Clive, it's Wayne, the dashing Wayne. Nothing wrong with Wayne getting married to Jenny at all. He now sits on half the estate, because if they had wills, they don't any longer have wills. What's Wayne likely to bring to the show? He's got his own children in Walter and Rose. Now, Walter and Rose, lovely kids. This is somebody now for James to go to weddings, funerals, and whatever else, christenings and stuff, and slide up and down the dance floor and stuff on his knees with Walter and Rose. He's got some friends and nice holiday mates and all the rest of it. But what he's not realised is that Walter and Rose, whilst they are his stepbrother and stepsister now, are potential beneficiaries to his mum's estate. He's not realised this, so he's still smiling, God bless him. So again, what happens if Jenny dies before Wayne? Remember, she's no will, she's dying intestate, and you know the result. She dies, everything passes to Wayne, and little smiling James, yeah, the link to James has gone as well. So Walter and Rose and Wayne are the ultimate beneficiaries there. These were really simple wishes, weren't they? Really, really simple, and nothing wrong has happened. It's just the result of actions and people doing things like getting remarried. It can be really, really tragic. Again, nobody's done anything wrong in these circumstances. So let's move on a little bit now then. This is a sad statistic in my mind, but what if Bob and Jenny were to get divorced? 1 in 2.5 marriages end in divorce. 1 in 5 children live in step families. The thing is, if they went to divorce court and the judge there said, yeah, okay, you pair, you're getting divorced, that's fair enough, split your assets in half and on your way. You go and pop off now, that's fine. But before you go, I'm going to ask, do either of you stand to inherit anything? And what the judge means in that circumstance, are any of you named in a will to inherit? Absolutely. Bob is. A simple will leaves things to named beneficiaries. And if that's the case, and you find yourself or your children find themselves in divorce court, as Bob has, he's got to answer honestly. He's in a court and he stands, yes, Your Honour, I stand to inherit £350,000. Says the judge. In that case, what I'm going to do, because of the circumstance, I'm going to award half of that to your ex-wife, Jenny. So Jenny is getting £175,000 of Harry and Janet's money even before it's got to Bob when they pass away. And the judge can put a marker on the property to make sure that that happens. Because assets that are likely to be inherited can be included in divorce proceedings, and that likely to be inherited means they're named in a will, a straight will without any element of trust. And that's really important and devastating to families, or it can be. Now then, watch this picture build. We've got Bob and Jenny, they've got divorced. They've still got James as their common beneficiary. What if we know that Jenny got remarried to Wayne? So we now know that Bob's married to Emma. They're got an instant handle on half of each of their half of the estate. James is still smiling at the bottom. They've got children. We know about Walter and Rose. We now know about Jake and Kelly. James has got 4 other playmates now that he can have holidays with and slide up and down the dance floor on his knees with. They are also beneficiaries, though, potential beneficiaries. So if that was to happen now, James is down to about £70,000, a fifth of his £350,000. He doesn't know any of this, of course he doesn't. But the problem comes when people start to die. Now, if you look at that picture, In the audience, there will be people here that have got that family makeup. If you've not, then you'll know somebody that has got that family makeup. A modern blended family, there's nothing wrong. It's positives coming out of negatives, and there's certainly no judgment in it. However, it can have a catastrophic effect on your legacy plan and what you want to go to who. And this is how. If Bob and Jenny die before their new partners, there they go, you'll see the links to James disappear. Now, this is where my slightly macabre sense of humour drops in, because poor James here has lost his mum, his dad, his grandma and his granddad, and he's lost his entire inheritance. He's not got a relative or a penny in his pocket, to be perfectly honest. He's still smiling, he's not realised this, but these other people that have inherited, neither Harry or Janet knew about Emma or Jake and Kelly. Yet they've taken half of the spoils of their hard-earned money, just the house and the £50,000, but half of it's gone to people that neither Harry or Janet ever knew. And they have dead simple wishes, really simple wishes. Wayne and Walter and Rose likewise. At least Janet had met Wayne and Walter and Rose, but Emma and others are total strangers. That's a real concern when you come across that. Now, this one some people know about, not many do though. If Bob takes his divorce money and he sets up a little business on the high street, sets up a coffee shop with a bit of a bakery out the back like you see these days, but he sets it up in January 2020, and we know what happened in March 2020 when the first lockdown and COVID, the full impact of COVID kicked in and his business failed. So at that point he applies for bankruptcy, and he has to, his personal assets become exposed to the creditors at that point. Similarly, the judge in the insolvency court can ask the question, do you stand to inherit anything? Yes, I do, says Bob. I stand to inherit £350,000. If, when the bankruptcy period has ended, that's 12 months, for a period of up to 12 years after that, if Harry and Janet die in that period, then the bankruptcy creditors have first dibs on their estate before Bob gets anything. And if that's £350,000, then that's a whole lot gone. And again, the judge can order that. So when a judge has ordered it in a court in England and Wales, then that's what's going to happen. And again, Harry and Janet sat in the house watching David Dickinson in the afternoon, minding their own business. Bob's gone bankrupt, he's in court, and the judge has made an order based on what they have in the bank and in their house. And that isn't to go to Bob, it's going to other people if certain things happen. Bit strange, that one, but be wary of it. It does happen. It's happened to clients of mine, or previous clients' parents, if you like. I'm going to move away from death and disaster a little bit, not quite the disaster side, but we're going to look at lasting powers of attorney and losing mental capacity. Now, if you look at the list on the left there, Alzheimer's, dementia, hospitalisation, physical infirmity, accidents and serious illness, I would hazard a guess that if you put your hands up now, you'd probably put your hands up for Alzheimer's and dementia being the primary cause of losing capacity. That's because we associate it with our elderly parents, maybe. However, accidents and serious illness are the bigger causes. And if you look at Kate Garraway recently, her husband contracted long COVID, serious illness. He'd not got any lasting powers of attorney in place. They had nightmares trying to access their family affairs, their own life, and to carry on their life as they like to, because he had no voice. He lost capacity and is in hospital. It can happen to anybody, this. And they're not old by any stretch of the imagination. I'm 59 now. I know you're all disbelieving of that and probably think I'm closer to 69. But my powers of attorney is set up. My son, when he was 19, he's an attorney along with my wife. They're in the safe. They're safe and sound. If I lose capacity, then things carry on. So, lasting power of attorney is the answer. Must be applied for and registered when a person has mental capacity. So as soon as Kate Garraway's husband, God bless him, contracted COVID, the mental capacity is gone. It's too late. They can't then retrograde apply. It's got to be done when you've got full mental capacity. There are two sorts. There's property and the financial affairs. That caters for your bank account, selling your house if you need to, looking after your mobile phones, your mobile phone account, internet, all these sort of things that Kate Garraway's husband has certainly set up for them, having nightmares because once you lose mental capacity, the Court of Protection will shut down everything in your name. or can shut down everything in your name. Bank accounts, like I said, businesses won't speak to you. And anything in joint names too. So the house is in joint names. So could you sell the house if your partner had lost mental capacity if you needed to? Probably not without lasting powers of attorney. And you couldn't cancel things like a mobile phone bill. Silly things, but really, really serious. And health and welfare. You might have been married for, I've been married for close on 30 years now, coming up to 30 years. If I or my wife went into a hospital, that marriage counts for nothing. I'd be asked the question, do you have power of attorney for your wife? Yes, I do. Doors open and you're involved in the process. If the answer is no, I don't, then doors are closed and you are pretty much excluded from the process, as Kate Galloway found out, unfortunately. And that's how that can happen very, very quickly. You don't know you're going to get seriously ill or have an accident. If you did, you'd step back from the bus as it was about to run you over, or you get down to the doctors or the emergency department and get yourself checked out. So it really needs to be put in place sooner rather than later. Don't wait and think, oh, well, we'll be in our 80s and 90s, because at that point you're more vulnerable and less likely to take on board the actual process. So sooner the better for lasting powers of attorney. If you don't, and this isn't scaremongering by any stretch of the imagination, but this is the alternative. If you don't have lasting powers of attorney in place and you lose mental capacity or the ability to make your own decisions, then one of the options is to go to the Court of Protection to appoint a deputy, or the family apply for a deputyship. That is a long protracted issue. Some local authorities support the process a little bit, but even with that support, it is still an absolute pain to apply for deputyship for a loved one who's lost mental capacity. Children sometimes apply and they don't get it because they might empty mum and dad's bank account, if you like, when they get access to it. So again, if that's the case, which takes 9 to 12 months, going to the court every few weeks with bank statements and receipts and invoices of what you've spent of your money on your family, asking for it back out of your bank account in some occasions. And that can be really demeaning and not a nice process. If you don't get it, the court will reject your application and award the deputyship to a retired solicitor, local authority officer, something like that, who'll be running your affairs, in this case, Harry and Janet's affairs. And the cost of it can be up to £2,170. That's a conservative price. There's ongoing charges as well. So if it was for both, that'd be £4,340. Bob's got to pay that. And Bob wouldn't get the deputyship, if you remember, because he's gone bankrupt. So they're not going to give a bankrupt access to mum and dad's account. He's not a good risk. So he's just spent £4,340 on mum and dad's deputyship applications. Doesn't get it, doesn't get the money back. That's gone out of Bob's pocket because he can't use mum and dad's money because it's locked down. Really important, lasting powers of attorney. Sometimes more important than a will, as it looks after us while we're alive and makes sure we're treated how we should be treated. So just bear that in mind, please. Lasting powers of attorney. Now then, let's go back to death, doom, and disaster, and we're looking at probate. So what is probate? Probate is when you die. It's everything, your executors submitting everything that you've got, and I mean everything you've got, to the probate office, and they'll decide, with the HMRC, they'll decide whether or not there's inheritance tax to pay. Now, everything goes through probate, everything that you've got. If you've got pensions and that sits in a pension pot, you're taking income, that can avoid probate. Life assurance, if that's going to leave things to a trust for children or things like that, then that can avoid it. But apart from that, everything else goes through probate. Everything's locked down until probate is granted. And then when the revenue have done their work and decided whether there's inheritance tax to pay, can be £1 million for a couple. Married couple, leaving the house to your kids, the inheritance tax limit will be about £1 million if the circumstances are right. If not, you've got less than that, then it's £650,000 per married couple, £325,000 each. Anything over that is taxed at 40%. Now, if you die, the married couple, leaving your house to your kids, and you died with 1.1 million, there's a £40,000 inheritance tax bill to pay, and your executors have got to pay that before the grant of probate, so they can't use the family money. It's a bit of a chicken and egg situation, but it's uncomfortable, and they won't give you the grant of probate until you pay the inheritance tax bill. So bear that in mind too. If you can avoid that, avoid it. Professionals, a solicitor will charge about 2% of the estate value, which will be about £7,000 for Harry and Janet. Banks and building societies, beware, they can charge about 8%. if they've done your will free and included themselves as trustees and executors. So that would be £7,000 versus £28,000. The average fee for a professional to do your probate is about £6,000. If you can avoid that or reduce that, then all the better. That's where some of the savings of a good legacy plan. So what did Harry and Janet do? Harry and Janet, after a couple of meetings with me, did one face-to-face, we did one on Teams, and then they decided, after having some information sent out what they wanted to do, they took out a legacy plan. I'm going to example the top of the tree, just so you can see what's achievable, really, with a good legacy plan. But there's any options under this as well. I'm somewhere in the middle. I've not got this top legacy plan. I've got a sort of middle one which fits my circumstances. So they took out mirror wills. We know what they are. They took out lasting powers of attorney. We know what they are. And they took out a lifetime trust. Now, that lifetime trust includes an element with the wills of some discretionary trusts as well, some trusts that are set up within the will. And this is what they achieved. Well, first of all, you can see a legacy plan. It's not just one thing. It's not just a will or lasting powers of attorney. It's all these things combined, and there can be other things in there as well. But this is as good as you'll get, really, for the amount of protection that you could possibly want for your family and your house. And we're looking at the house, really. If you leave your house to your kids, then generally speaking, we're doing okay. The kids will be doing okay. So I'm going to look at protecting Harry and Janet's house. This is what they achieved. There was no sideways disinheritance when they took this legacy planning out. All the things happened, but they didn't get any, nothing went sideways to anybody else. They ensured that Bob could take over without delay or cost if they lost the affairs. So if they lost capacity, they've got the lasting powers of attorney in place. There was no probate for their estate because the house was looked after in a trust, and that passed through and round the back of sort of probate, and that can be achieved. And at the very least, will reduce the cost of your probate as well, and created a family legacy that lasts for generations to come. So once a trust is established, it can last for 125 years, and you can pass that down to families, avoiding things like generational inheritance tax, which is really, really important if you've got more money than average, if you like. So how does it work? Well, a family trust, any trust, is really like a legal strongbox. And when you put things into this legal strongbox, it's drawn up by the barristers and the lawyers that draw these things up. That legal strongbox is safe and secure. Harry and Janet have got full control over it, so they put the house in there. It says they put the savings in, but we'll concentrate on the house for now. So you put your house into that family trust. Harry and Janet have got the key to the box, nobody else. It's locked down. They're trustees with a life interest, so they don't lose control of that. It doesn't avoid inheritance tax at that point. What they're doing is actually protecting it against sideways disinheritance and other things. So they get the keys to the box. Bob can be a trustee. You can appoint a professional trustee as well. Bob's a beneficiary and James is a beneficiary too. But they don't get a key. They don't get access to that until Harry and Janet have gone. Really, really important. This is how it works. Now, as an individual, you have legal liabilities, if you like. You can be asked questions like, do you own a house? Yes, we own a house, or I own a house, or I own this, or I own that. If that's in a family trust, we make the trustees and beneficiaries a group legal entity, so they're all forming part of the trust. So that individual legal liability is removed. Now, what it doesn't do is stop Harry and Janet doing what they want with the house. They can move, they can downsize, they can do whatever they want. And if you imagine having a £20 note, you don't own the £20 note itself. That belongs to the Treasury, that piece of plastic paper. But you can do what you want with it. You can spend it, save it, you could give it to me if you wanted, you can even gamble it if you want. So you've got beneficial interest, but not formal title to it. So this removes the title to the house from Harry and Janet to the Harry and Janet Family Trust. And that gives it an awful lot of protection. Nothing new about trusts. Trusts go back to the Middle Ages and beyond, really, when the people were riding out doing what they were doing in the Middle East. Many years ago, the Crusaders, when they came back, somebody had taken over their land and their property because they'd not left it in trust. Nobody knew the family lineage. So they started to, when they left in future, they left it in the trust of the local clergy who knew the family lineage. So they knew if they didn't come back, who was next in line to inherit it. And that's how far back it goes. There's nothing new about this. The landed gentry of this country, the rich and famous, if you like, do actually have most of their stuff tied up in some form of trust or another. And those trusts that we set up are discretionary. So what happens, I'll show you shortly, is that all these people have got personal liabilities. They get married, they get divorced, they become ill, they die, unfortunately, and they inherit. Now, that's because they inherit because they're getting stuff directly from a will that leaves things to them, absolutely. And when you inherit, you're liable to sideways disinheritance. When you use a formation of trusts, a family trust and others, to look after your affairs, there's no personal liabilities because it's owned by the group. Don't forget, they don't get married, they don't get divorced, it doesn't become ill, it survives for 125 years if you want it to, and there's no need for inheritance. So when you're asked in court what all your kids are when they get divorced, do you stand to inherit anything? No, I don't stand to inherit anything, Your Honour, or at least I don't know what I stand to inherit, because that's coming to me by way of a discretionary trust, and I'll only get it when the trustees decide to give it to me based on my mum and dad's guidance. Different story. That removes the sideways disinheritance. So whether it's a trust set up within your will or a trust set up outside of your will, or a combination of both, which is the favoured route, then that protects against all these things that we talked about today and we looked at. So who benefits? Well, all these people benefited from a simple will, didn't they? Just having that simple will, all these people with those things that kicked in were quite catastrophic. As soon as Harry and Janet held the meeting, they sat down and said, yeah, Mark, we like what you're talking about, we're going to put everything into a family trust. Then you can see there that everything that Harry and Janet have got is going to everyone that they love. Nobody else is getting a sniff. All the stuff can happen just the same as it did in our presentation, but nothing comes out of the family trust. Everything goes to Bob, everything goes to James as their really simple wishes. That's all they wanted to happen. But because of the things we've seen, if one of those things happen, then it can be catastrophic. If you look after your affairs by way of a system of trust, family and will trust, then we can protect against that sideways disinheritance, which is the big thing. So let's have a look. Harry and Janet in their lifetime decide to protect the house. They put it in a family trust and look after the house. And when they're gone, that passes down to Harry, but only when they're both gone. Bob. Bob then picks up the family trust, and he can put something into the trust if he wants, or take it out, and he can put stuff in and pass it down to young James as it is he wants to. If inheritance tax was due when Harry and Janet had died, it wasn't, but if it was, then Bob would still have had to pay that. But as that estate passes down to young James, that amount that passes to him by way of trust is excluded from James's estate for inheritance tax purposes, or from Bob's estate for James's inheritance tax purposes. Hence why, when God rest the Queen Mother died all those years ago, how much do you think her inheritance tax bill was? She probably got an awful big estate. Zero, actually. She paid nothing, or her estate paid nothing, because it had all come to her by way of different trusts, and everything was held in the trust name. And again, when royals divorce and split, the partners don't leave with half of Windsor Castle or anything like that, half of Buckingham Palace, because they're owned by trust. They're not owned by those individuals. And if you ask a really, really wealthy person what they own, they probably won't own in their name very much. It's looked after by way of trust. And that's a similar thing that we need to. James can pass that on and pass that down to his beneficiaries, should he wish to, down the line. Really simple, and I know I'm whistling through this, but we are up against time a little bit. But this is what they ask. So these are some of the questions that are perhaps in your mind. Now, will we lose control of our home and savings? Absolutely not, no. You remain trustees with a life interest, so you retain control. If you just set up will trusts in your wills and the other one's got full first precedence on the trust, then you can spend what's in the other trust. You can live your life as you were doing before your partner passed away. But there's that element of protection as well. You take precedence all the time. Could we still sell and move home? Yes, you can. Well, your home's in a family trust. You can sell it, you can move, and you can put the new house in trust. Quite a simple conveyance to do, and we'll help you through that should you wish to set that up. If you wanted to, could we close the trust? Of course, if Harry and Janet had set up this trust and then they decided to get divorced, then it probably isn't the best thing. So we would help you to dissolve the trust and dismantle it and maybe set up individual plans rather than a joint plan. So yes, you can. Now then, can we add and remove beneficiaries? Yes, you can. So your beneficiaries are receiving what you want them to get by way of a letter of wishes, a memorandum of wishes. That's a discretionary letter. So if they've got, if Harry and Janet have got young James in as receiving £20,000 when he's 18, and he starts, how can I put this, shoving stuff up his nose that he shouldn't be doing and doing unsociable acts and things like that, they can actually scratch him off the beneficiaries list until he gets his act in order and starts behaving himself and getting a little bit older and more responsible. So they can take him off, of course they can't, and put him back on when he mends his ways and starts behaving himself a little bit. So you can have a bit of fun with your grandkids if you want by setting this sort of thing up and having a little bit of control if that's your thing as well. So it's really important to understand that just because you set this up, you don't lose any control. Now then, should you guys all go out now, get a meeting, have a meeting with me, and then we'll go for a lifetime trust, will trusts, a will and lasting powers of attorney? Absolutely not. I've already explained that I'm somewhere in the middle here. I have will trusts set up, which give me an awful lot of protection, and me and my wife have got lasting power of attorney for each other with our son and each other as attorneys. So that suits us at the moment. We just moved house, so I've not put our new house into trust as yet, but ultimately it will go into a lifetime trust. But somewhere on this scale will be you. That will fit with you and where you are in life and your family circumstances. If you've got a will already, I'll be very happy to look at that will for you, have a quick conversation to see what you think it wants to achieve, and I'll let you know whether it does achieve it or not. If you've not got a will, then we can put your will in place. If you know people and you're thinking of people now, like might be mum and dad, we really need to get lasting powers of attorney in place for mum and dad, then that's something that I can do for you as well, and we at True Bearing can do. So wherever you fit on that scale is what's right for you. Doesn't matter what's right for me at all. None of this is on a commission basis. I take a salary, a modest salary. I would say that, wouldn't I? But I'm salaried. So if you go for a simple will, that's important to you and that's the right thing for you. Doesn't matter whether you take a simple plan or a more complex plan for me. Financially, and that I wouldn't do it otherwise. I don't think this works on any other basis than that, really. And it's got to be the focus has got to be on you guys and getting the right legacy plan for you, making sure that your affairs are looked after how you want them to be looked after. So that's really important. Now then, I think that's probably about me. I'm on about 40 something minutes there. This is what I do. And again, it's specialised in supporting our clients to achieve maximum protection for their assets. And it is that supporting, giving you the options. If you have a meeting with me further down the line, and there is a process to do that afterwards, there's some information sent out to you. If you'd like that meeting with me, there's no cost to that meeting at all, or any meeting that you have with me. Only at the end of the day, if you decide that you want to do something or take advantage of a particular solution, then of course then that needs paying for, but that's it. You're not paying for me to come and see you or all the teams meeting or whatever else we do. And then finally we'll do all the full attestation with you and sit down and do the make sure everything's signed up properly and legally. So I hope that that's been helpful. A little bit about data protection there that'll if you just do a quick scan on that, I'll ask questions later. Joking. And that's who we are, True Bearing Legal Services, part of True Bearing Chartered Financial. We're based in Chorley, but we travel all over the northwest, well, all over the country really. So if you'd like a meeting and you find that interesting, I'd like to know a little bit more, then please let the powers that be know. And that, folks, is me. Thank you very much for listening. I hope this goes back to the presenters now. I'll stop sharing my slides and then we'll see where we are. Okay, folks, thank you.